Good morning, and welcome to the May 2021 arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I will be presiding over today's proceedings. Before I call the case on this morning's docket, I'd like to take a few minutes to introduce our panel of distinguished judges today. First, Judge Michael Boozer has served on this court since 2005 after litigating for many years with a law firm in Kansas City. And Judge Amy Klein has joined our court this year, coming from a law firm in Wichita. As I mentioned, my name's Sarah Warner. I became a member of this court in 2019 after practicing in Lawrence. In preparation for today's argument, we judges have thoroughly reviewed your briefs and the court record, along with a legal memorandum that's been prepared by a research attorney. We are familiar with the facts of the case, but because this argument is streaming online and will be archived, I've asked appellant's attorney to provide about a 1-minute factual summary as to how we got here and the issues that are before us before diving into his argument. The case is scheduled to be argued with 15 minutes of argument each side, but I've told the parties that I'm going to be a little bit more lenient on that, just so we have some time to delve into the interesting issues before us. I will be keeping time, and including any rebuttal time that is requested and granted to the appellant. So at this time, I will call case number 122810, Kelly Rowe Appellee versus Phillips County Hospital Appellant. Would the parties please state their appearances?
Good morning, Your Honor. Russ Keller on behalf of the appellant, Phillips County Hospital, and with me on the video is Mr. John McClymont.
Kelly Rowe, on behalf of myself for appellee.
Mr. Keller, would you like to reserve any time for rebuttal?
Your Honor, I don't think I'll make a advance request for time. If there's any time left over after the court's questioning, I will use that for rebuttal, but I'm not going to specifically reserve any time.
Okay, thank you. Counsel, you may begin.
Great, thank you. And to follow on Your Honor's suggestion at the beginning, in terms of a brief summary of the case, the parties to this case, as just revealed by the appearances, the appellant is Phillips County Hospital, our client, and then the appellee is Ms. Kelly Rowe, here representing herself today. And there are two principal issues in the case. The first issue is whether the Kansas Open Records Act allows a requestor to determine the format of materials produced under the statute, including a native-based electronic production format. And the factual background of that issue is Ms. Rowe made a number of requests under CORA seeking materials in an electronic native-based format, and the hospital agreed to provide those, but not in the native-based electronic format. And so that is the core of that first issue before the court. The second issue has to do with the attorney-client privilege. And the factual background there is there were some filings in the district court, the proceedings below, where attached to one of the filings was a recording of an executive session of the hospital's board. And the disagreement between the parties on that issue is the hospital's position is that the materials at that executive session were covered by the attorney-client privilege. And then Ms. Rowe, her position is that there is no privilege, and even if there was a privilege, it was waived for a variety of reasons. And the district court ruled in her favor on that issue, as well as on the summary judgment issue, the first issue we described. So I hope I've, Your Honor, described the issue sufficiently. If not, please tell me and I'll add some more detail.
Thank you. I think that is sufficient.
Okay, may I proceed?
Yes.
Thank you. May it please the court, as I mentioned, I'm Russ Keller, and I'm very pleased to be representing the appellant in this matter, Phillips County Hospital. And as we've just sort of alluded to in the summary, the core issue in this case is whether the Kansas Open Records Act allows a requestor to demand production in the format of her choosing, including in a native-based electronic format? And we submit, Your Honor, that the answer to that question should be no, contrary to what the district court held in this case. The long and the short of it, Your Honor, is that the statute unambiguously does not say that a person making a KORA request can demand production in any format of her choosing. And as the court knows from reading the briefs in this matter, there are 3 provisions in KORA relied upon by the district court and Ms. Rowe, and also by the amicus parties who filed a brief to a friend of the court brief as well. So let's take those 3 provisions in order, because I think examining the text is very illustrative to this core issue in the appeal. The first provision relied upon by Ms. Rowe in the district court is at 45-219C2. That provision says that each agency can prescribe a reasonable fee when it provides access or makes copies of various records, subject to the following. In the case of fees for providing access to records maintained on computer facilities, the fees shall include only the cost of any computer services, including staff time required. That provision of the statute is not ambiguous, Your Honor, and it makes perfect sense. It essentially says, if an agency decides to grant access to computer records, access as opposed to copies, it can't send a bill to the requester saying, here, pay for copies for these materials that were made available access-wise through a computer. It absolutely does not say that a requester has the right to demand production in the format of her choosing. The second provision of the statute relied upon by the district court and Ms. Rowe is just a little bit further down in that provision. It's 45-219G. That says nothing in the act will require an agency to allow a person to obtain records by inserting, connecting, or otherwise attaching an electronic device provided by such person to the computer or other electronic device of the public agency. Once more, that's not ambiguous, and it makes perfect sense. It essentially says a requestor cannot march into the agency's office and say, I want to attach a thumb drive to your mainframe computer. That's not something a requester has the right to demand. It does not say the requestor has the right to demand production in the format of her choosing. And finally, Your Honor, there's the third provision relied upon by the district court and Ms. Rowe, and that is at 45-221A16. That provision says a public agency shall not be required to disclose software, the programs for electronic data processing and documentation. However, the agency has to keep a register, a public register, and that register must describe the information the agency maintains on the computer facilities and the form in which the information can be made available using those existing computer programs. Once more, Your Honor, the provision is not ambiguous and it makes perfect sense. Say, for example, you have an agency that has a high volume of consumer transactions and it uses software to keep track of those transactions and to execute them. A requestor cannot march in and say, give me the software as part of a KORA open records request. However, that doesn't mean all the information is shielded from disclosure, and that's why the agency must keep the register specified in the statute to say, here's the information that's embedded in that program, and here's the way we could make it available to you if it's relevant and otherwise responsive to a KORA request.
Counsel, would you agree that KORA contemplates the disclosure of electronic files or electronic records in some instances?
It is certainly contemplated that that could be one format of production. I will agree with that, Your Honor. It doesn't go the next step and say it must be disclosed in an electronic format. That's left to the discretion of the agency. And
but
again,
if a record, a record under KORA is broadly defined to include, among other things, a recording, an electronic recording, an electronic file. If that's the case, and if there is a duty to disclose a record, and if the default is disclosure, then why is there not a duty to disclose that electronic record instead of another electronic record of that record, if you will?
Well, it's the same record, Your Honor. I mean, it may be in a different format, a paper copy versus, say, an emailed version record, but it's the same record. And by the way, Your Honor, there's no allegation in this case, for example, some of the things you cannot see in a printed copy. For example, the formula of an Excel spreadsheet. There's no allegation that in any board meeting of the hospital, they sat down and said, hey, let's have a discussion about the background formulas of an Excel spreadsheet. I mean, those aren't relevant. And probably more important, Your Honor, policy choice. The legislature could say, requestor, you have the right to obtain a record in any format that you choose, including a native-based electronic format. That's a policy choice. Wise or unwise, it's one the legislature has the right to make. And the issue in this case, Your Honor, is whether, as the district court did, that policy choice should be made by the judiciary by implication, by implying from provisions of the statute that don't actually say that there's such a right, but yet implying it because there's other general references to computer records. And again, we submit the answer to that question ought to be no.
But isn't it true that the disclosure of public records is the rule, right? We're talking about exceptions to the rule, whether a record need not be disclosed, say, in a particular format or the nature of that disclosure, but disclosure is the rule.
Correct. And the hospital at all times has agreed to disclose the records that Ms. Rowe has asked for.
Mr. Keller, in your brief, you say the plain language of KSA 45219A alone is dispositive of the issue. And I understand that language to be that CORA provides that a person may make abstracts or obtain copies of any public record to which such person has access under this act. Is it your position that the plain language, a plain reading of the word copies, means that you are not required to produce the information that you've agreed you're going to disclose in any particular format, because copies is a very broad term?
That is the position we took in the briefs, Your Honor. And if I may add a line of detail to that argument with your court's permission.
Sure.
The core issue, that we led with that argument. You're absolutely right to point that out in our briefs. And we have made that argument about the term copies. The core issue, both in subsection A of 219 and the rest of 219, is does that provision or anywhere else in the CORA say there is a right of a requester to obtain documents in the format of her choosing, including a native-based electronic format? We think the unambiguous text there and elsewhere answers that question because the right's not there. You have to infer it to get there. If the court moves into the sphere of inference, in other words, trying to divine legislative intent by reading the tea leaves of other portions of the statute, that's probably where subsection A becomes most relevant, because as the court knows, we've also made an argument where we've listed 218A, 219B, 220A, and a variety of other provisions that essentially say, there's a good inference to be drawn that various issues were left to the discretion of the agency as opposed to being affirmatively mandated. And so I would put as well some of these arguments you've just raised, Your Honor, sort of in that category, if the court makes it to canons of statutory construction, which we don't think you have to do because the statute's unambiguous.
Thank you.
And I should add a line of detail about this right not being in the CORA as it currently stands and how this is a policy choice. And I think what's particularly informative on that point, Your Honor, is that the Kansas legislature is imputed or otherwise knows the subject matter of its own legislation. We've cited a number of cases to that. And we know it is very easy to write a clear and unambiguous provision that says, requestor, you can ask for the materials in the format that you want, including a native-based electronic format. We see that in the federal legislation, the FOIA. It's very clear in that statute. And as we've cited in our briefs, you can see that language in other sister state statutes. The example we've given you is Kentucky. The Kansas legislature knows that. it knows that either directly or by imputation. Yet, in the dozens of times the KORA has been amended since its passage in the early 1980s, not once has the Kansas legislature ever added that language to the statute. That speaks volumes, Your Honor, about how the district court went awry when it implied that right based on otherwise unambiguous provisions of the KORA that simply do not say that right exists. And I should add, Your Honor, that the policy of liberal construction, there's no doubt it exists, it's in the KORA, we don't dispute that, but it's insufficient to sustain the district court's order on this issue. I mean, the relevant provisions, as we've just covered of KORA, are actually not ambiguous. They have a clear purpose, they have clear language, and there's no ambiguity, so the court doesn't have to enter into the territory of statutory construction, invoking the liberal construction principle. But even if it does, we've cited a number of cases that are very clear that that principle doesn't authorize a district court to add language to a statute that otherwise doesn't readily appear, even if the district court thinks the legislature made a bad policy choice or the legislature made a drafting error. A district court is simply not entitled to do that under the liberal construction principle or otherwise.
Counsel, isn't it true that in 45-217, public record is defined as any recorded information regardless of form, characteristics, or location?
That's true. That is the definition. You're right.
So metadata would be included in the definition of a public record, or the formula in the spreadsheets like you mentioned before?
Well, it could be, but again, there's an easy way to specify that metadata is part of a record. You could read that provision exactly as you have, Your Honor. That's a reasonable reading of it. However, we know from the provisions we've just covered, including the FOIA and the Kentucky statute, et cetera, a legislature can be specific about that. And it can say, yes, you can have metadata. You can have everything that comes along with an electronic record. Our legislature has not done that. And again, even if metadata is part of a record, there's really no allegation that the things that are hidden, formulas in an Excel spreadsheet, are relevant to any request that's been made by Ms. Rowe in this matter. She may want to manipulate things by getting electronic copy, but you're not entitled to that under the statute, nor are you entitled to the cheapest manner of production either. And, there's case law cited to that effect as well.
Counsel, of course, the relevance of particular information isn't relevant, if you will, to whether it should be disclosed under KORA. Isn't that right?
You're right about that, Your Honor. It's not relevance in a litigation sense. You're absolutely right. It has to meet the terms of the statute, and then the request, for example, it has to be a public record, just as your colleague has defined in there. So I agree with you. It's not relevance in the litigation sense. You're right.
And counsel, you mentioned earlier today that the hospital provided Ms. Rowe an opportunity to inspect the records. But did I read the information correctly that that opportunity was to inspect paper copies and not electronic copies?
I believe that's correct, Your Honor, that it was a paper copy that was made available.
So how would Ms. Rowe be able to inspect the metadata of documents or formulas in spreadsheets under the option provided by the hospital?
She wouldn't. You can't see formulas in a paper copy, and so you can't see that material in a printed copy, and I'm not going to argue otherwise to you, Your Honor.
And you're not claiming that in a paper copy that the hospital produced, the hospital would have the ability to redact the author of the document or the creation date before providing that paper copy, would they?
No, a lot of those documents will have the author and the creation date directly on the document itself, but no, we're not. And as you've sort of alluded to, or your colleagues have alluded to, the hospital didn't invoke an exception in this case. So no, we have not claimed that there is an exception that's available here.
And isn't that what metadata is essentially? That's who wrote the document, who modified the document, when it was modified, when it was created, that type of information.
It's data on the data. That's right. It's background information. It's non-substantive. It's that type of information. That's correct.
And it's not standalone information. It's part of the record, isn't it? The metadata?
Well, I think that's debatable, again, in part because the legislature can say, with full awareness of the subject matter, the legislature knows everything we're talking about here. Metadata is not, a strange issue to any legislature that has passed an open record statute. They're aware of these issues, but they haven't said that. They haven't said, metadata is part of the document. All we have is it's admittedly broad, but we only have a generic definition of a record, as the court has, read into the record here during this oral argument. But that's different from saying, as other states have done, as the federal government has done, yes, requester, you get that if you ask for it. You get the metadata. You can ask for native-based electronic production. Our legislature has not done that. And our
But
view is that
it did choose language that was broad enough to include metadata, didn't it?
Conceivably, but it could have specified that right, and it did not. And the act of not specifying it, especially when there are policy issues wrapped up in that. I mean, for example, we won't get into the details, but the court's seen it in the briefs. Once you go into the realm of metadata, there are a number of policy issues, about how to handle the metadata, whether you have to redact it, whether there's going to be drafts in there, whether or not those issues are present in this case. They will be going forward if there's a mandate from a court to say, yes, you have to produce materials in their native electronic form if it's requested by the person making the core request. There's going to be a host of policy issues related to that, which is yet another reason we shouldn't infer that right, because the legislature can decide how it's going to handle those policy issues having to do with metadata. It hasn't done that, and we shouldn't make that choice for them.
How did the legislature address those situations in 45-221 when they talk about several exceptions and give the ability to redact attorney-client privilege information, draft information? I mean, those are all sorts of things that could be scrubbed electronically, just like they're scrubbed in paper version, correct?
I'm not sure that's a full substitute for all the dealing expressly with all the policy issues wrapped up with metadata. And again, we know this is possible because we see it in the federal legislation and we see it in the legislation of other states. We know we can do it. Our legislature hasn't. So I would be hesitant to agree fully to Your Honor's question there.
And when you talk about policy issues, doesn't 45-220 mandate that a public agency should adopt procedures request to address a situation, and the procedures have to provide full access to the public records?
Yeah, that's right. I think you're quoting the statute there, Your Honor, and certainly we don't contest the language of the statute. And it's similar to Judge Warner's earlier question that the presumption is access. That's true. I mean, that is how the core is written. It's how it's set up, that the presumption is for access. So I agree with that.
And if I give you a paper copy, that's not going to give the metadata information. That's not going to give you access to the metadata. Or if I give you a paper copy of a spreadsheet, that's not going to give you access to the formulas used to create the information in the spreadsheet, is it?
That's correct. You can't see the formula in a paper copy from an Excel spreadsheet. That's right.
Can the metadata be put into a written format?
You are testing
a hard
here.
Copy.
Yeah, you are testing me here, Your Honor, on computer knowledge. And so I'm not sure I can fully answer that question. I suspect I'm not going to venture a guess to that question, Your Honor. I'm not sure, right, is the honest answer.
Let me ask you this. Was there any testimony below with regard to metadata, what could be found in these records, how it could be manipulated, anything like that? Was any of that presented to the district court?
Well, the district court did make some findings where, for example, it said the hospital, somewhat, at least regularly, will email things or have, send spreadsheets that way. So there were some findings of that nature, Your Honor, at least on summary judgment in the record. I'm not sure if I'm getting it to your question. I hope I am, but there are some findings of that nature in the record, Your Honor.
Well, I guess it seems to me we're getting into an area of expertise, computer expertise involving metadata. And I don't see that anywhere in the request, there was a request by Ms. Rowe for metadata to begin with. But apart from that, it seems to me that you would need some expert testimony to talk about the ramifications of metadata. Where does it end? Where does it start? How can it be created? Can it be copied in a hard format? And I just wonder whether any of that was brought out in the district court.
I'm not aware, Your Honor, of expert testimony in the record below on these computer-related issues. If I've overlooked something, I apologize. I'm not aware of any expert being designated on that issue.
Counsel, I'd like to step back quickly to that broad definition of record that my colleague read from the statute. And is it your position that the absence of metadata as an exclusive term that would be included in that list. Does that render the statute ambiguous, or does that mean, in your view, that this was an intent by the legislature to exclude that from the definition of a record?
Your Honor, I hope I'm answering your question. If I don't, I'm sure you will tell me here. But our position is that the definition of records doesn't override or otherwise affect the fact that the legislature chose not to put into the statute a provision like the one the district court imputed, which says you have a right to get materials in a native electronic production format. It doesn't say that anywhere in the statute. And the definition of record is not broad enough, nor do I think it's ambiguous in the sense of overriding that legislative choice. So I hope that if it doesn't answer your question, I'm sure you will tell me. But that is our position, Your Honor.
I'm just looking for it. It feels like we're talking about whether the statute or the act is ambiguous or not. And so I'm just wondering where on that spectrum does the absence of the specific term metadata within that definition fall?
I don't think it renders the statute materially ambiguous. I will say that, Your Honor. We have a definition of records there. It's admittedly worded fairly broadly, but it's not ambiguous. And it's especially not ambiguous as applied to native-based electronic. I mean, we've been talking a lot by metadata, but we're actually talking about something even broader than that, which is native-based electronic production, which includes metadata. But it's a format that is distinct from a paper copy format. And again, the legislature knows of this issue. It knows how to address it, and it chose not to. It never inserted into the statute saying you can get native-based electronic format, which would include metadata if you get it in that format. It chose not to do that, despite amending the statute dozens of times, being fully aware of the FOIA and being fully aware of statutes like Kentucky's. It hasn't happened. And that's why, the specific issue in this case is quite important, because as the court's questions have touched on, the district court's order and then in turn this court's order will influence countless CORA transactions going forward. But that specific issue is embedded in a larger issue that is as old as our legal system itself, namely the balance of power between the branches of government in our tripartite system. I mean, more than 130 years ago, none other than William Blackstone wrote that when the legislature positively enacts something, judges are not at liberty to reject it, for that were to set the judicial power above that of the legislature, which would be subversive of all government. So this is an enormously important question, Your Honor, and the district court didn't honor that principle by inferring, pulling pieces of the statute, whether it's the definition of a record or the three provisions that have been cited in the parties' briefs, to say that that right does exist despite the lack of any plain language saying so. And it was also contrary to the long line of Kansas Supreme Court cases, which counsel restraint when interpreting a statute. And again, I won't go through those cases. I know my time is short. I'm happy to touch on the second issue if I have enough time remaining. If not, then I will rest at this point, absent any further questions from the court.
I would say that we have gone over your 15 minutes, but
I thought so.
If there are questions from the panel on that or any issue, certainly I'm happy to allow those. All right. Thank you, Mr. Keller.
Thank you.
Ms. Rowe, we went 24 minutes, and so you'll have just about that much in terms of argument as well.
All right, I don't think I'll need that. I think you folks have probably addressed pretty much everything I was going to bring up as points with regard to CORA. CORA, by default, requires openness. The definitions are that all records, regardless of form or characteristics, are considered disclosable unless there's a specific exemption, either in the statute or common law, that precludes that record from being disclosed. And the agency bears the burden of establishing why that record should not be disclosed. And the courts, the Attorney General's office have all made it very clear that computerized records are records under CORA, and they are to be disclosed and provided in the form requested if the agency is capable of providing the record in that form. The hospital has not claimed that it's not able to provide the records in the form requested. It just doesn't want to. And it hasn't provided any information saying that there would be any confidential information included in any of the metadata or the formulas or anything. It's made no such allegations. It just simply doesn't want to provide the electronic records and doesn't think that it has to. And if you go through, let's see, I got to go through my notes here now, since we can truncate a bunch of this. You have Attorney General opinions that require a public agency to make copies of records in any format. Quote, computerized, the Attorney General back in 1989 provided that computerized public information must be provided in the form requested if the public agency has a capability of producing that form. Even currently, which I just accessed their website yesterday, the Kansas Attorney General still states in their FAQ regarding FOIA that computerized information can meet the definition of public record and must be provided in the form requested if the public agency has the capability of producing it in that form. The Supreme Court in Wichita Eagle noted that any non-exempt document, computer file, or tape record in possession of an agency is subject to public disclosure. Didn't recognize that the computer file would be able to be converted into a paper record, which is what the hospital proposes to do, is actually convert a record into another form, and thus we would lose potential information, even the ability to modify it.
Ms. Rowe, I wanted to ask about that.
Yes.
So the hospital has repeatedly offered to make copies, hard
Right.
copies of this information. And I'm just wondering, from a practical standpoint, from your view, why is that not specific? What information are you seeking from these native format documents that aren't available in another format?
I don't know, honestly, without seeing the record. Specifically, the spreadsheets are obviously, you're going to have formulas, you're going to have potential references to other cells within those spreadsheets, but it also goes to the broader, it should be required to be provided, notwithstanding my intent or whether the information is available in another form. The CORA does not require that I provide the reason why I want the information, just that, arguably, yes. Some of like a basic PDF, the information may be the same if it is printed out. Excuse me. But if the agency had highlighted in the information or, whatnot, that may or may not come out in a paper copy. I don't know. Without seeing the electronic record, what would be in there or is not. But the fact is that the act itself does not explicitly give the agency the discretion to make the choice.
We have consistently interpreted that act as to provide the agency discretion as to how to disclose, in what format to disclose those records, right?
I'm not sure that's the case. From my review, it's always been in whatever format the agency is capable of providing it in, that they didn't necessarily have the choice of the format. If it's in a particular format, they don't have to design, they have the discretion not to have, if you need a particular program to disclose the information, say, and that the agency doesn't have that program available, it has the discretion to either create that program or allow the requester to create that program. That's where the discretion comes in. But I'm not sure in the format, to change the form of the record is has been held by any court or the Attorney General.
Well, there are certainly practices that have allowed the agencies to determine how they want these requests to be made and then how they can respond to those requests.
Sure. Correct.
And those have been upheld by the courts.
Correct. Yes.
Ms. Rowe,
Yes, sir.
is it your legal position that the relevant KORA statutes giving common words their ordinary meaning are plain and unambiguous and thus require no statutory construction?
Yes, that is correct, Your Honor.
Do you consider the word copy to be ambiguous?
I do not believe so, no.
And do you find anywhere in the statutes where it requires a request or a agency to produce a record, an electronic record, if it is demanded or sought after by the requester? Is there any specific language in KORA or Kansas statutes that relates that specifically mentions that however whatever format the requester wants the copy to be given to them, that the agency has to provide the copy in that format requested?
I believe in that two things. I believe that the KORA itself requires the copy to be provided. It does not require the agency to convert. So say, for instance, I wanted the record exists in a paper format and I make a request and request that the agency convert that paper record into a PDF. No, that's a conversion. That's not a copy, just as likewise, if the record exists in a doc file format, for instance, a Word format, and I did not, if I were to request that be converted into a PDF, I don't believe that, because again, that's a conversion. That's not a copy of the actual record. What a copy of the actual record is a actual copy of everything that's in that record as it exists at that moment. So a doc file, a copy of a doc file would be a doc file. And that copy can be produced. An exact copy is, simply provided either by an agency thumb drive, by email, which it does all day, every day, sticks documents as they existed at that time, as they were made, maintained, and or held by the agency at that time, stick it in email, ship it off. That's copy in my understanding.
All right, I guess
under KORA.
Here's what I'm getting at. I look at the statute and I don't see that the statute requires that an agency produce a copy of a public document in the format that the requester demands. I do see that language in some old Attorney General opinions. I do see that language in the district court's order. I don't see that language in a statute. And so that's my question. Are you aware of any specific statute that says the format that the requester demands has to be met by the agency, has to be complied with by the agency?
Not that specific language, no, but to be liberally construed and that public records shall be open is in the language. And it's my position that, and I think it's a reasonable and rational one, that had you mentioned the older Attorney General opinions, including that language, the legislature has been well aware that that has been the opinion of the Attorney General's office, who is charged with enforcing KORA. If the legislature had not intended that result at any point, even after this case, if this panel decides that electronic records must be disclosed in the format in which they are made, maintained, or kept by the agency, the legislature at any point can change the law and negate that. It has not done so yet. indicating that over the past 35 years, CORA is being enforced exactly as it was intended.
You know, in reviewing Judge Pratt's opinion, I noticed a number, almost exclusively, citations to what I am referring to as older Attorney General's opinions. And I noticed that there was no reference to the CORA statute provisions, number one. And number two, I noticed that there were two brief mentions, but no discussion of the latest Attorney General opinion, which relates specifically to this topic because it was the Attorney General's opinion based on complaints that you had made to the Attorney General about these exact topics. How do you reconcile you seem like you're relying a lot on those older AG's opinion, but the latest ones looking specifically at this topic, not on voter rolls or anything like that, seems to say that there was no violation of CORA. How do you give me your best argument on that?
Okay. When I review that letter, relied on those older Attorney General opinions as well as Harder. And I'm honestly not able to reconcile it. I don't know, unless the only argument, as I explained a little bit earlier, that the discretion argument makes sense, given the statute, given those older opinions, which were relied upon recently, is the conversion aspect. That yes, the agency would maintain discretion to over, I cannot demand, I don't think there's any argument under the law, whether it's in the statute or in any case law or any Attorney General opinion, that I can command I can demand that the agency convert the record into whatever format I want. But I'm not sure if that's the Attorney General's letter didn't distinguish those two issues. They just kind of made a blanket, the agency maintains the discretion, even though all of the opinions it cited state the opposite.
Well, and you can see from my standpoint, the judge is relying on all the older AG's opinions, and that's his precedent in effect.
Right.
He's not relying on statutes or case law. Well, he's relying on some statutes, but not on the case law. He's focusing on these AG's opinions.
Right.
Here comes the AG's opinion that looks specifically at this and says, no, this is not a viable argument. And I don't have any discussion about it, but I don't know why I can't cite that in an opinion from our court to say the AG's latest look at this. They've had a change of heart for whatever reason, or they're distinguishing factors in the cases. Why I can't rely on most recent AG's opinion.
You can. I just think that the AG's opinion is unsubstantiated. Again, because the way that they relied on those older, they too relied on the exact same older Attorney General's opinions and came to the opposite conclusion without really explaining why.
On this issue of metadata, did you specifically request metadata in any of your requests for open records?
I did not, but nor did the agency claim any was confidential. I mean, so.
And in your opinion, would it be necessary for you to request metadata under an open records?
Not in my opinion, it's part of the record. Metadata is inherent in that record. And if any of it needs to be segregated for confidentiality reasons or whatever, that's incumbent upon the agency to do that segregation before the record is disclosed.
I was just looking at page 31 of your brief where you say, even if any alleged metadata suggested a separate draft document, a requester would nevertheless be required to request that separate record. So it seemed to me you were suggesting that you had to specifically request metadata as
No.
part of your records request.
No, what I was getting at is the hospital in their opening brief had made the argument that just by disclosing the metadata, that they are automatically disclosing the other documents, that there was any, let's see if they had, I don't put their quote in there, but they were complaining that if they disclose the metadata, then they're disclosing those preliminary copies. And that's not the case. The metadata doesn't contain any previous drafts or copies or whatnot. If I saw in the metadata that there had been a previous draft, I would have to request that separate draft. All the metadata would tell me would be if there was a separate draft, maybe when the last changes were, when, what who the author was, but it wouldn't actually provide me the separate document. If I wanted an earlier draft, I would have to request that separately.
Can metadata be converted to a paper record?
That I don't know. I don't.
Was there any expert testimony or any testimony at all with regard to metadata and the computer implications of those different formats?
No, sir.
Thank you.
Ms. Rowe, I was hoping that you could step through a kind of a hypothetical situation with me. I understand that these aren't the facts of this case, but of course we have to think about not only this case, but how our decision in this case might affect things down the line.
Of course.
And so let's say that there is an Excel spreadsheet that includes within it personally identifiable information that an agency maintains. Would you agree that that personally identifying information the agency is absolutely prevented from disclosing by
Yes.
law?
Yes.
So in that instance, if we issued a ruling that said that there was an obligation to provide a document in a native format, how would an agency reconcile that obligation under our ruling with its legal obligation to redact all of that information? We're not talking about something where you could have like a protective order in litigation. We're talking about a legal obligation to disclose a public record.
The agency, so even if it were a paper copy of something that contained confidential information as well, that could not be disclosed, or they were prohibited by law, or even, discretionarily through one of the exemptions that they could redact, they could remove that information. The agency would still have to justify, they'd go through the record just like any other paper record, and then exempt that material out of the record, just like it would any other paper record. So for instance, an Excel spreadsheet, they could go into that spreadsheet and redact that information out and then disclose the rest of the record as a spreadsheet. I think as a practical matter, that wouldn't be impossible.
So they would alter the document and then provide you an altered document.
Just like a paper copy.
But again, it's my understanding that alteration would include in its metadata that those alterations had been made, right?
I don't know the answer to that. Maybe that the alteration was made, but not the content of that alteration. I'm just, not providing any sort of expert opinion on the matter, but just as a practical, from my experience. But even let's say none of, they couldn't reasonably segregate that information from that electronic record, then they would likely have the argument that the only way they can provide the record would be as a paper copy in that instance. But where there is no confidential information, where an agency has made no claim of any sort of information that needs to be deleted or segregated from the record, there is no argument against providing that electronic record.
And I just want to go back to what you said. You said that there could, the agency could indicate that it couldn't provide that or make that argument. I mean, that contemplates that there would be someone to decide that argument, right? I mean, so this contemplates the possibility of litigation on each of these requests. And rather, do you think that that's what the legislature intended Cora to, how the legislature intended Cora to work?
I do. That's just like any other exemption. The burden is on the agency to justify why it's withheld any information, whether it's a public record, whether it's an audio, or whether it's a paper record, an audio file, a photograph, anything of that nature. The burden is always on the agency to justify the exemption. And if the requester doesn't agree with that justification, litigation is always an option, whether it's an electronic record or whether it's a paper record, whether it's a photograph, tape recording, any type of public record. It's not just limited to this instance to this type of record.
Ms. Rowe, it looks like we're at 22 minutes. Colleagues, are there any other questions on this issue?
Just one for Ms. Rowe. We know that at the time Kansas passed this statute, that it patterned it, I believe, after FOIA and the Kentucky statute. And at that time, nobody had nothing about native language, whatever. Subsequently, FOIA and Kentucky have brilliantly in one sentence addressed this issue and addressed it in a way I think that Ms. Rowe, you would be in favor of, which says, yes, you got to produce it, and it has to be done as the requester asks for it. Since that time, as counsel pointed out, there have been a number of cases where Cora has been amended, yet the Kansas legislature has not followed the pattern of FOIA or Kentucky. Is that relevant as part of our analysis as to what is the meaning of the Cora statute?
To a certain extent, yes, because in going through the legislative history of Cora, of FOIA, and the Kentucky statute and FOIA did not, in fact, contain the same language that Cora actually did, that it was to be liberally construed and applied to promote the stated policy openness. Both FOIA does not include that broad, that firm of a stated policy, nor does the Kentucky statute. Kansas took care of that in one fell swoop at the beginning, that everything, that it's supposed to be liberally construed and applied to that result. FOIA and Kentucky had to expand their statute because it was more restrictive. It wasn't as broad. The policy was not as inclusive as Kansas. And Kansas, I cannot speak for the legislature, obviously, but they wanted everything included unless specifically exempted out. And yes, sir.
Well, excuse me. So your argument is that Kansas, by having a liberal construction, in effect, took care of all of that and said, yes, whatever the requester demands, it has to be produced in that format. See, Kansas didn't need the separation of the one sentences of FOIA and the Kentucky statute.
Correct. If I'm understanding what you're saying, then yes, correct.
Any further questions from the panel?
No. Thank you.
Ms. Rowe, if you'd like, you can take about 30 seconds and wrap up.
I don't even know how to. It's so nebulous. I think I've said, I respectfully request that this court affirm the district court's finding and require computerized public records to be provided in their existing native-based format if the public agency is capable of providing the records in that format.
Thank you. Mr. Keller, looks like we went about 26 minutes, so you have 2 minutes if you would like to provide any rebuttal.
Your Honor, thank you for that. You've been super patient with the party's time. I don't think I'm going to take more of your time on the Cora issue. And with 2 minutes, I fear that I can't really do justice to the privilege issue. So unless there are further questions from the panel, unless the panel wants to hear something on the second issue, I will not beg your indulgence to take even more of your time and rest on the arguments that have been made thus far.
Any further questions from the panel? All right. Counsel, thank you so much for your very insightful arguments today. We'll take the matter under advisement and we'll issue an opinion just as soon as we can on this issue. Thank you so much.
Thank you, Your Honor.